Hey everybody, John Skiba here, and in this video, I'm going to discuss with you whether it's safe to talk settlement with a debt collector who's filed a lawsuit against you. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll be notified each and every week when I put out new videos to help you deal with your serious debt problem. All right, let's talk about settlement in the context of a debt collection lawsuit. Now, if you've been dealing with debt collection, you're getting phone calls, you're getting letters, and you're likely getting something said to you, or even in the letters, that's along the lines of, this communication is from a debt collector, this is an attempt to collect a debt, and any information obtained will be used for that purpose. It kind of sounds like you're being arrested, doesn't it? It kind of sounds like you're getting your Miranda rights, you know, that you have the right to remain silent, and anything you say will be used against you in a court of law. And in fact, that specific language, it comes from the Fair Debt Collection Practices Act, the FDCPA, which is a federal regulation that's over debt collectors that really governs what they can and can't do in the collection of a debt. And we actually call it in the legal world, this is called the mini Miranda, where they're required to put that on letters, they're required to tell you that when they contact you, to let you know that they are, as a video I did recently, they are not your friends. They are there to get information from you that they're going to use to try to collect on that debt. So you may be asking yourself, you've been sued by a junk debt buyer like Portfolio, Midland, Unifund, one of the big debt buyers. They filed suit. You know, I've talked to a lot of people who are like, hey, I just want to reach out and get this thing resolved and settle it, but I'm afraid to really talk to them because I don't know what they're going to take and use against me. Well, if a lawsuit has been filed, you're in luck because there are some protections in place that allow you to talk freely with them in trying to resolve it. The rules of evidence. So the rules of evidence are these rules in each state, and there's federal rules as well that govern what comes into the court and what does not as far as evidence goes. And there's a rule, and in most states it's going to be Rule 408. Under the federal rules of evidence, it's Rule 408. Most states, they kind of copy that or mirror what the federal rule is. And so Rule 408 essentially says that settlement discussions between the parties in civil cases are not admissible as evidence in trial or in a motion for summary judgment. So basically, you can reach out to the junk debt buyer, you can talk to their attorney or whoever it is who's on the other side, and you can offer some type of proposal to get this case resolved. And you can do so without the fear that they're going to turn around and say, hey, judge, they've already offered to pay us a third or a half or whatever the settlement was, clearly they must owe it. You have that protection under Rule 408 because it's not admissible as evidence against you. So as you're doing that, if it's something you're just trying to get resolved very quickly, you can reach out to them, submit this proposal, knowing that even though they're providing you with that mini Miranda, telling you that the information that's obtained will be used in collection of the debt, it's not something that can be submitted as evidence to prove that you actually owe the debt. So I hope that that's helpful as you're trying to resolve the debt issue, particularly these junk debt buyer cases. Settlement is often a decent route to go, particularly if you can get a good deal. And if you reach out early, often you can get that before you go through this whole litigation process, and you can do so with the confidence that it's not going to be used against you if the case does proceed to trial. I hope that's helpful today. Thanks for watching.